Our next speaker is Professor Ron Delisle. Ron has been a professor of law at Queen's University for more than a decade now. He interrupted his teaching career at Queen's a number of times to pursue other vocations, notably a 5-year stint as Provincial Court Judge, Criminal Division in Kingston, and a period of time as Director of the Federal Law Reform Commission's Evidence Law Project. He's written extensively in the fields of criminal law and evidence law, and has just recently completed an innovative, problem-oriented course book in evidence law. His long-standing and widespread reputation as a consummate teacher has recently achieved formal recognition through the bestowal upon him of the Queen's University Alumni Excellence in Teaching Award. More than 10 years ago, he taught me criminal law and made it appear coherent, even though he had a problem for every answer. He's also served the profession diligently through participation in continuing legal education programs, notably the Federation of Law Societies' intensive summer criminal law program. Ron is a rare combination of law reformer, scholar, teacher, arbitrator, and judge, not necessarily in that order. And we're fortunate today to be able to share his views on hearsay, which derive from that cumulative experience. Ron? Okay.
Thank you very much, John. It's a pleasure for me to be here today. My topic is, as John says, hearsay evidence, but I hope really to use that as a vehicle for discussing and advocating with you a particular approach to all of the rules of evidence. The paper I'm delivering, as John says, is actually part of a book that will be coming out this spring, and the book reflects a new style of teaching evidence. Some years ago, I can recall talking to Stan Schiff, who many of you have had as a teacher, I'm sure, and he pointed out to me when we were working together on the Code of Evidence for the Law Reform Commission that he said, what this country needs is not a good code of evidence, but rather a good course in evidence. I share that thought, but for years I and my colleagues have taught the law of evidence by virtue of the case method. It seems to me now that while much can be said in favor of that method for developing analytical skills, it is simply not very efficient, particularly when it comes to teaching procedural subjects. So much time is spent in the classroom, quote, taking up the case, making sure that everyone understands the proposition of law that is there reflected, that there's little time left to discuss the reason and the history that underlies the rule. And precious little time is available to discuss how the rule ought to be used. When I was sitting as a provincial court judge, I was frequently dismayed at the inability of counsel, none of whom are here present, their inability to use the rules in practice. Particularly, I was dismayed when they were former students of mine, who were able to describe the rules, were able to describe the law, but for some reason were unable to use it. And the height of that, I'll give you this anecdote. I was trying an income tax case, and the federal prosecutor, Mr. Hogan, was introducing his evidence, and as you're aware, under the Income Tax Act, various easing provisions are given to the prosecutor, and he was introducing his case entirely by paper. And of course, he had that ability because so many of the documents are, according to the Income Tax Act, self-authenticating, simply accompanied by affidavits. So he filed this mountain of paper in front of me and said, that is the case for the Crown. So I turned to the defense counsel and I said yes. And he walked forward to the bench and he threw a piece of paper down on my desk and walked back to the counsel table. And I said, what, pray tell, is this? And he said, that, Your Honor, is the defense. And he did it with such a flourish And I said, yes, but how did it get here? He said, I put it there. I said, well, mechanically, I'm aware of that, but normally when a piece of paper is filed, one calls a witness who then authenticates that this document is what counsel suggests it might be. Now I said, where do you get the authority to do that? Well, he said, my friend did that. And I said, yes, but he had the authority of the Income Tax Act. Do you have any authority? And I can still recall he said, what sauce for the goose? I resolved at that time that there has to be a better way to teach evidence. And the, quote, better way, I feel, is to simply tell the student, so far as you are able, in a written text, what the general principles are. So that nowadays what we do in law school is we discuss, they having read the text, the reasons, hopefully, the reasons and the history that underlies the rule. And then at the end of each chapter, we have a series of problems. So the major part of the class is taken up analyzing those problems. And then the students play the roles of objector or resistor or judge and see how the rules act in action. It seems to me that more time needs to be spent on why and how rather than on what, because the what can be communicated by the written word rather than in the classroom. And so I come to this point and say that a practicing lawyer, too, cannot use the rules of evidence unless he knows why they're there. If he knows why, then he can perhaps persuade a judge that though the tendered evidence appears to fall foursquare within a certain rule, it ought nevertheless to be received because the reason underlying the rule is otherwise satisfied in this particular case. Our law of evidence appears to be relatively certain because we have all of these rules. But it seems to me that we must recognize that underneath these rules, a great deal of discretion exists in the trial judge. About 10, 12 years ago, I was asked to write a paper for the Ontario Law Reform Commission on evidence, on their project, on discretion in the law of evidence. And so I spent my time, first of all, going to the various indices, looking up discretion. And it's not there. It's not in the indices. And so I went to the cases and started reading as many evidence cases as I could. Spent 3 or 4 months. Academics can do that. Reading evidence cases, always on the lookout for discretion. I approached the task believing that the law of evidence was a whole series of rules with a little bit of discretion here and there to help in the implementation of the same. I came away from the task thoroughly convinced, as I am today, that the law of evidence is a whole bunch of discretion with a few rules here and there to guide the judge in its exercise. The basis for all rules of evidence is discretion. That's how the rules come into being. That's how it is today, whether we recognize it or not. I can recall when the Law Reform Commission of Canada, in its code of evidence, when it reported, the profession didn't welcome it with open arms, so to speak. One of the main criticisms of the proposed code was that it had too much discretion given to the trial judge. My suggestion is that the common law reposes that discretion. I was so pleased here this morning to listen to His Lordship's talk on similar fact evidence and then Ms. Arnup's excellent presentation on corroboration, because both of them, recall, highlighted that discretion is at the root of both of their problems. Recall similar fact evidence. This morning we learned that there was a time when Lord Herschel spoke in the Macon decision and said, this is the rule, and then we grafted on a variety of exceptions. He said this was the rule, and here are a variety of exceptions. Now, thankfully, as the result of a case Boardman, our own Ontario Court of Appeal, Sheldon Paquette, and others, we approach similar fact evidence as an exercise in discretion. We simply take a look and we ask, how cogent is this evidence? Bearing in mind the normal reason that we excluded in the past was prejudice to the accused in the sense that the jury might improperly use this evidence for a purpose other than it was tendered, then the trial judge has to bring to that matter his judgment, his concern. That's what he's paid for. It's a very fine line. My friend over here this morning and listening to Justice Martin said it's a fine line making that decision, and so it is. But that fine line is not to be determined mechanically by asking, does it fit within a certain pigeonhole? Rather, it's an exercise in discretion. His Lordship this morning noted for us the case of the dredging scandal case, the McNamara decision. I'm given to understand that it was he that wrote the central part of that judgment on similar fact evidence. And it was he in that judgment who said, embracing the thoughts of Professor McCormick, the time has come to stop pigeonholing things. The time has come to approach it in a balancing exercise. Recall last year, was it last year? The years go by now quickly. The case of Grat in the Supreme Court of Canada, coming out of our Ontario Court of Appeal, on the opinion rule. And Mr. Greenspan is arguing police officers can't give their opinion as to whether or not the person was impaired. It's not within the various exceptions. Recall the old case of German, which said, yes, there is an opinion rule, but there are a variety of exceptions. An individual can speak to identity and speed and age and impairment and so on. And thankfully, in Grat, the Supreme Court of Canada, per Dixon, says, no, it's a question of discretion. It's a question of asking yourself, is this opinion helpful? Is this the way a witness would normally speak to another in describing the matter that they personally observed? Veterivic, as Ms. Arnup points out for us this morning. 150 years ago, some judge said to himself, this is an accomplice who is testifying. We should be concerned about his evidence. He might be purchasing immunity by this evidence. Perhaps I should warn the jury of that fact. That seems to me to be a salutary exercise in discretion. But then over a course of 100 years or so, lawyers in their formalistic way add all sorts of details until it becomes like a complex tax statute. And thankfully, in Veterivic, Justice Dixon says, the time has come to recognize it's an exercise in discretion. And so we come, finally, I suppose, to my paper on hearsay, because the thrust of what I want to say about hearsay is that it, too, ought to be approached as a discretionary exercise. I tell you a little story about a case that happened in my county town of Kingston. And His Lordship, then G. Arthur Martin QC, as he then was, came to town to defend a local hotel owner on a charge of supplying liquor to minors. This is a very important case, not because of who was charged, but rather because of who was representing. Everyone went to watch that. And I recall a few days before the trial, the Crown Attorney in that case, speaking to him over a drink at someplace, said, I have this case coming up next week, and have to prosecute the hotel for serving liquor to minors, and have to prove the age of the children. And I said to him, you might find it instructive to read a case called Peacock. It's a decision of a county court judge in Ontario about proof of age. And he said, fine. Then came the trial, and the Crown called one of the found-ins, a local college student, and said, what's your name? And he told him, and he said, how old are you? And he said, 17. And do you have any proof of that? Yes, this is my birth certificate. And G. Arthur Martin stood up and said, I object, that's hearsay. And the Crown Attorney said, I'm afraid that my learned friend has not read the case of Peacock. He said, the head note of which says that the age of a child can be proved by the child's statement. And G. Arthur Martin said, well, unlike my learned friend, not only have I read the head note, but I've read the entire case. And I would like to distinguish that case on the basis that in Peacock was the accused, and he was the young child, and he was being prosecuted for drinking underage. And in that case, the police officer was permitted to testify that when he apprehended Peacock, he asked Peacock how old he was, and Peacock said 17. And so that case is clearly distinguishable, because that was an admission. And the case was won. If my Crown Attorney friend had read the entire case, he would have seen that the county court judge there said, as G. Arthur Martin noted, that it is an admission. But the county court judge also said, you know, when it comes right down to it, a child should be able to tell you how old he is. There are circumstances of guaranteeing the trustworthiness of that, and even without the admission, it ought to be received in my discretion. So that's where I'm coming from. Now, I'm given to understand that all of these papers will be published at a later time, and so you'll have it in all the details, so I won't read everything, most of it. I want to read something about the history of the rule, because I think the history of the rule is useful. I think it's also quite interesting. And we should bear in mind that the exclusionary rule prohibiting hearsay did not come into existence until the latter part of the 17th century, as the jury's role in fact resolution completed its evolution into its present form. The jury, as we know, initially was not to decide issues on the basis of evidence produced in open court. Its members were selected because they had knowledge of the facts. Insofar as their knowledge was imperfect, it was their function to investigate and gather information from those who were knowledgeable. The members of the jury were witnesses from the community, selected by a public official who then tried the case. We must not think of them as coming into our court ignorant, like their modern successors, of the cases about which they were there to speak. The verdicts were given and founded on hearsay and tradition. It was not until the latter part of the 15th century that ordinary witnesses, as we know them today, casual witnesses, as Bentham called them, began to testify in open court about disputed facts. Though witnesses began informing the jury in the latter part of the 15th century, their importance was slight still in comparison to the jury's informing itself. This gradually changed during the 16th and 17th centuries, and we reach a stage where the prime source of information for the jury is evidence presented in open court. The jury ceases to be witness and becomes solely trier. Coincident with this development comes the need for the exclusionary rules of evidence, as the jury is directed to rely only on what they hear in court. There's obviously little need for exclusionary rules prior to that time. In 1553, we see the first statutory attempt at reform. Although it was confined to treason trials, it demanded, and this was a revolution at the time, the production of the accusers at the trial. They were there to confront the accused. This requirement was a marked departure from the then normal criminal trial process wherein previously sworn depositions were routinely filed. I came across the case of Sir Walter Raleigh. You see how much time we have to read these things? And I was reading the case of Sir Walter Raleigh, and he was prosecuted on an indictment to commit various treasons. He demands his statutory right, given to him by this recently enacted statute, to be confronted with his accuser, Lord Cobham, and he is refused. And this is the transcript. I think it's delightful. Raleigh, the proof of the common law is by witness and jury. Let Cobham be here. Let him speak it. Call my accuser before my face, and I have done. All this is but one accusation of Cobham's. I hear no other thing. I beseech you, my lords, let Cobham be sent for, charge him on his soul, on his allegiance to the king. If he affirm it, I am guilty. By the rigor and cruelty of the law, the accusation may be a forcible evidence. And the Lord Chief Justice says, that is not the rigor of the law, but the justice of the law. Else, and I love this, else, when a man hath made a plain accusation, by practice, he might be brought to retract it again. If he said something before, accusing you, and then we bring him to court in front of your face, your counsel might get him to retract that. I think that some Crown attorneys might prefer the earlier practice. And Raleigh says, oh, my lord, you may use equity. And Lord Chief Justice says, that's from the king. You get justice from us. He says, this thing cannot be granted, for then a number of treasons would flourish. The accuser may be drawn by practice while he is in person. And Raleigh says, the common trial of England is by jury and witnesses. And Warburton says, I marvel, Sir Walter, that you, being of such experience and wit, should stand on this point. For so many horse stealers may escape, if they may not be condemned without witnesses. Raleigh says, I know not how you conceive the law. The Lord Chief Justice says, nay, we do not conceive the law, but we know the law. Raleigh then appeals to the Old Testament and talks about Susanna having been condemned and Daniel coming to his aid, and says, good, my lords, let my accuser come face to face and be deposed. And the Lord Chief Justice says, you have no law for it. And so this was the criminal trial practice back at that time. But gradually, during the 17th century, the new ideas do take hold, and concern for the worth of hearsay does yield an exclusionary rule. In the beginning, it's only oral hearsay that is inadmissible, and sworn depositions are received. But gradually, as the parties take greater control over what evidence will be presented, not the jury, not the judge, but the parties, and they begin to challenge the worth of evidence presented by their opponent, then the adversary system is born. And with the adversary system comes the peculiarly English technique of cross-examination, insisting on the witness's presence. With those developments, then, we see that the hearsay rule is automatically born as a natural counterpart. Juries are then to be informed by witnesses with personal knowledge, speaking on oath, publicly, in their presence and in the presence of the parties, and are to open themselves to cross-examination when they express themselves. If the evidence is otherwise, it is to be excluded as hearsay. Two early cases example this. I'm going back to a case in about 1695, a case called Braden and Speak. It's lovely when you don't have to give the citations and you know that the citations are going to be in the footnotes later, and then you can read them there if you like. Lord Chief Justice Jeffreys, remember hanging Judge Jeffreys, is presiding. The accused seeks to lead evidence, and Jeffreys says, "Does she know anything of her own knowledge?" And Braden, the accused, says, "She can tell what she heard, my lord." And Lord Chief Justice says, "'Tis no evidence. Where's the woman that told her? Why isn't she brought?" And counsel for Braden says, "They say she's so big with child, she can't come to the court." And Lord Chief Justice says, "Well, if the woman was here, and if she said it, and wouldn't swear it, then we wouldn't hear her. How then can her saying it be an evidence before us? I wonder to hear any man that wears a gown make a doubt of it." So there's part of the reason for the hearsay rule, the requirement of an oath. But later, even though the out-of-court saying was given on oath, we see it was rejected if there was no opportunity for cross-examination. In a case called King versus Payne describes that. The rule is now settled law by the turn of the 17th into the 18th century. It's obviously a source of pride to the English lawyer. This is a note from 1730. "The excellency, therefore, of our laws above others, I take chiefly to consist in that part of them which regards criminal prosecutions. Here indeed it may with great truth and justice be said that we have by far the better of our neighbors, and are deservedly their admiration and envy. This might be made to appear in many particulars. In other countries, the witnesses are examined in private and in the prisoner's absence. With us, they are produced face to face and deliver their evidence in open court, the prisoner himself being present and at liberty to cross-examine them." With that background about the history of the rule, I'd like to talk a little bit now about the reason for the rule. It is sometimes said that the hearsay rule was fashioned out of a distrust for the jury's ability to adequately assess the worth of the evidence. But the history that I've described above seems to me to confirm Professor Morgan's view that the rule has little to do with the credulity of jurors, but rather with the credulity of witnesses. And that what we're really looking at is that the hearsay rule was fashioned to protect the adversary in his ability to cross-examine. Nevertheless, I'll agree that distrust for the jury's capacity to adequately assess hearsay evidence did become an after-the-fact added justification. The trier of fact will be more assured of accuracy in his decision if descriptions of events are given in open court rather than through an intermediary. Trustworthiness of decision-making is enhanced for a number of reasons which may be grouped under two heads. First, the witness who speaks in open court is subject to a perjury prosecution should he lie. The witness who speaks in open court is encouraged to speak honestly and without exaggeration by the solemnity of the occasion and by the presence of the party against whose interests he speaks. His manner of speaking, his demeanor, will also be available for review by the trier of fact. The second group of reasons resides in our adversary system and in the faith that we repose in, as Wigmore said, the greatest engine ever invented for the discovery of truth, cross-examination. The description of a past event, and here I'm simply paraphrasing Professor Morgan, obviously. The description of a past event by a witness has present within it the possibility of error due to at least four reasons. The description may be defective because 1, the witness didn't perceive the event accurately. 2, the witness doesn't remember now the incident accurately. 3, the witness's language describing the incident may be ambiguous or otherwise defective, and the communication of his thoughts may therefore be misunderstood. And finally, Perry Mason style, the witness may be insincere. These four dangers may be guarded against by canvassing their existence through cross-examination, which of course is only possible when the individual with the personal knowledge is present in the witness stand. The adversary may be greatly prejudiced if the description comes in through the relation of another who has no ability to aid in exposing possible defects in perception, memory, communication, and sincerity. I think if we keep this history and this background of reason present to mind, we're better able to deal with the ever-recurring problem of identifying hearsay. I don't know what your experience has been, but frequently in my court, the witness who would be testifying, there would be an objection made, objection, Your Honor, that's hearsay. Too frequently, I thought, opposing counsel would immediately search for an exception to justify the reception of the evidence, rather than saying to himself, is it hearsay? And frequently you're sitting there supposedly as some impartial arbiter, and you want to reach out and ask, and you resist that because that isn't judge-like. But you see them debating as to whether or not it fits within an exception, asking yourself all the time, is it hearsay at all? Professor McCormick, I think, defined hearsay in the best possible way. He said, hearsay evidence is testimony in court, or written evidence, of a statement made out of court, the statement being offered as an assertion to show the truth of matters asserted therein, and thus resting for its value upon the credibility of the out-of-court asserter. Notice particularly the closing lines of that definition. Resting for its value upon the credibility of the out-of-court asserter. Why is that a requirement? Because we just discussed above, the principal reasons for excluding hearsay evidence are the lack of protective safeguards of oath and cross-examination. Safeguards which are only necessary when the value of the evidence rests on the credibility of the out-of-court asserter. A sues B for failure to deliver lumber in accordance with their contract. B defends, denying the existence of a contract. A calls X to testify that he heard B unequivocally and unambiguously agreeing to deliver lumber to A on a certain day at a certain price. Clearly, this isn't hearsay, as we care not whether B was sincere in expressing his desire, his intention to accept the terms. The legal consequences of a valid contract are produced by the fact that B spoke the words, and the value of the words does not rest on the credibility of the out-of-court asserter. Proof of statements constituting defamation would not offend the hearsay rule. The proponent of the evidence is obviously not attempting to prove the truth of the matter asserted. Words accompanying actions often characterize the same, and if the substantive law has an objective test of intention, the words are receivable. They don't depend on the credibility of the out-of-court asserter. Statements made by suspects during the course of a police investigation, which are established as false, may be received as non-hearsay, evidencing a consciousness of guilt, the very fact of the statements having been made. The list of situations of relevant non-hearsay statements and their variety is limitless, and their identification is only eased when the purpose of the hearsay rule is kept in the forefront. And now I'm sure I'm going to take most of you back to law school and talk about a case, classic law school case, of Subramanian and the public prosecutor. Do you recall Subramanian? He was charged and convicted in Delisle with carrying ammunition, which is contrary to the emergency regulations then in existence. And he defended on the basis that, well, they told him to do it. The terrorist who found me in the jungle pointed a gun at my head and said, you'll carry this or I'll shoot you. And the trial judge at the time said, that's hearsay. What you have to do is call the terrorist, which is a very difficult task. And he's convicted, and he appeals to the Privy Council. And thankfully, the Privy Council set it right. Having more difficulty with this. There we go. And the Privy Council said, evidence of a statement made to a witness by a person who is not himself called as a witness may or may not be hearsay. It is hearsay and inadmissible when the object of the evidence is to establish the truth of what is contained in the statement. The Privy Council then noted that the value of the impugned statement in this case didn't rest on the credibility of the out-of-court asserter. The value of the evidence was in the fact of the statement having been made, since if believed by the accused, it would substantiate his defense of duress. The trier of fact would not be misled, nor the adversary prejudiced, by the absence from the stand of the terrorist declarant. If the terrorist were called as a witness, as the trial judge had hoped, what questions would the adversary ask? Could the adversary ask the terrorist if he was sincere when he threatened the accused? If he intended to communicate a threat? Surely those questions would be properly objected to as immaterial, since the issue before the court was not the terrorist's state of mind, but the accused. A more modern example might assist. Let's come up a few years to a case called R versus Dunn. R versus Dunn is a Nova Scotia case on wiretap. It has its counterpart here in the province of Ontario in the case of Cremascoli and Goldman. On a charge of threatening in the case of Dunn, the Crown needed to establish that the interception of the telecommunication containing the threat was lawfully made. As you know, the wiretap provision of the Criminal Code provide that an intercept is lawfully made if the recipient of the communication has consented to the interception. The prosecution sought to lead evidence of conversations between the police officer and the victim of the threats, she now being deceased. In those conversations, the victim had given her consent to the interception. She said, "Go ahead." The defense objected to this evidence as hearsay. The court agreed, and the evidence was ruled inadmissible. Fortunately, the court found the necessary consent by implication from other evidence, and later the court had another look at it, and in the course of its reasons for judgment, confessed its error in identifying the evidence as hearsay. The court had initially failed to recognize that the value of the evidence did not rest on the credibility of the out-of-court asserter. The police officer had been tendered to testify to an objective fact of a consent being given, a fact that he personally observed, about which he could be cross-examined as to whether or not, in fact, that consent had been given. The relevance of that resided simply in the fact of it having been made. The adversary was not prejudiced in being unable to cross-examine the complainant regarding what she meant by the words she uttered, and the trier of fact could equally well decide, without her presence, whether the words uttered amounted to a valid consent. This area of identification of hearsay brings up a rather nice academic problem, which you may recall called implied assertions. No one would deny, I'm sure, that statements can be made otherwise than by words. A nod of the head can communicate assent as readily as the word yes. Pointing to a suspect can be as devastating as someone saying, "That is the man." Actions which are intended by the actor to be assertions are obviously then capable of being treated as hearsay utterances. But a much more difficult problem presents itself when we have conduct which has relevance in the case only because that conduct has resident within it an implied assertion about facts that the actor has perceived. That's a long sentence. Perhaps I can give an example. The hoary example that I use is the one that good Baron Park gave us in the old case of Wright versus Tatum. The ship captain going aboard ship. Is it fair to lead evidence of the conduct of a deceased sea captain on a question of seaworthiness, who, after examining every part of the vessel, embarked thereon with his family? The ship has now gone down and there's an insurance claim, and the question is, was the ship seaworthy? The captain didn't say anything to anyone, but he evidently examined the ship and walked up the gangplank. That conduct amounts to, the good Baron said, an implied assertion by his conduct that he believed the ship was seaworthy, and therefore would be properly characterized as hearsay. testing it by the criteria we've just announced, does it rest on the credibility of the edict assertor? Are there any questions that you'd like to ask? I suppose there are. You might like to ask the ship captain, when did you examine the ship? How thoroughly did you? Do you have the expertise to properly know? These are all questions that the adversary might like to ask. And so I think that the House of Lords properly identified it as hearsay. The only problem I have is that Wright versus Tatum, while it's a House of Lords decision 150 years ago, is the only case to my knowledge that has ever properly identified the matter as hearsay. Let us come across to our country, case of Wysochan, case in Saskatchewan, back in the 30s, defended by a very able counsel, John Diefenbaker. Wysochan is charged with murder. 3 people were present together in a room. Wysochan, the accused, and a man and his wife, Mr. and Mrs. Kropa. Those 3 people know what happened in the room. After a shot or 2 was fired, the 3 people come out of the room or out of the house, and bystanders hear the wife turn to her husband, Stanley, and say, "Stanley, help me. There is a bullet in my body. Stanley, help me. I am very hot." And John Diefenbaker objects that that's hearsay. At the trial, Mr. Kropa says it was Wysochan that did it. Wysochan says it was Mr. Kropa that did it. This piece of evidence is introduced by the Crown to indicate conduct on the part of the wife towards her husband, which would be an implied assertion that it wasn't you, dear, that did it. If it wasn't him, it's got to be Wysochan. And John Diefenbaker says that's hearsay, Wright versus Tatum. And the Saskatchewan Court of Appeal says it's a piece of original circumstantial evidence, a fact, a statement was made, help me, there's a bullet in my body, from which we can infer that she believed it was not her husband that did the dastardly deed. Again, I don't think it was properly analyzed, although it may have best been received in any event. Now I want to talk a little bit about approaches to hearsay that we might take with that sort of background. There's a few quotes here, and you can read them later, I think. My message is this, I think. How should a court, an advocate, you, approach the admission of hearsay? By force-fitting the evidence into pigeonhole exceptions, which were created generations ago. You recall, for example, the case of Meijer versus DPP. Meijer versus DPP was a case where the Crown sought to establish a conspiracy to traffic in stolen cars. And in order to perfect their case, they had to establish that these cars that were seized were the ones that were taken from the manufacturer. They sought to do this by the introduction of business records, declarations in the courts of duty. That was recognized and still is, and is an exception to the common law. Declarations in the course of duty are receivable. But declarations in the course of duty are only receivable if the declarant is deceased. In this case, the Crown has a hurdle because he doesn't even know who the person was that made the record. This is an assembly line process. These are business records being made. The industry and the social conditions have vastly changed in the past 100 years, and he can't satisfy this requirement. And the House of Lords says, well, the law regarding hearsay evidence is technical. One would say, quoting Lord Reed, absurdly technical, but that's the state of the art. Because the House of Lords said, you see, the last time we ever created an exception to the hearsay rule was in the old case of Lord St. Leonard's, Sugden and Lord St. Leonard's. That was back in 1873. That was 100 years ago. And so we can't be creating exceptions now. That was for the judges back then. Now what we'd have is a rigid form of hearsay rule and exceptions. And judicially, we can't do anything about it, but please, and Lord Reed pleads and says, please will the legislature do something about it. Well, about 2 years later, the Civil Evidence Act of 1968 in England did. They radically reformed the hearsay rule to the point of view that it's practically non-existent now. Well, that's how Meijer and the House of Lords approached it. Well, then we come across to Ayres versus Venner, my favorite case in the law of evidence, a decision by Justice Hall, who knew what he was talking about in a discretionary approach to the law of evidence. You recall Ayres versus Venner. The plaintiff had suffered a broken leg. He was out skiing. At the hospital, Dr. Venner attended, reduced the fracture, and applied a full leg plaster cast. The trial judge received in evidence notes which had been made by the attending nurses. The nurses described the plaintiff's toes as blue, bluish pink, cool, cold to the touch, and were found to be relevant to the issue of the doctor's negligence as the trial court made the crucial finding, quote, "The classic signs of circulatory impairment manifested themselves clearly and early." And the trial judge received this evidence on the basis that there are circumstances guaranteeing trustworthiness. Why? These nurses are trained observers. Little motives to lie. When they're making these notes, they're subject to supervision. If the supervisors would detect whether or not there was anything wrong. Taking all that into account, they decide that it is receivable. The Alberta Court of Appeal says no. There's fruitful areas for cross-examination there. It is hearsay. And it goes to the Supreme Court of Canada. And Justice Hall says, well, I see what the House of Lords did in Meijer versus DPP, but after all, the judges made the hearsay rule. Why can't they reform it? And in effect, said to the profession, I believe, let us reform it together. And he ruled that there are circumstances guaranteeing trustworthiness, and that is sufficient. It is noteworthy, but not necessary to the decision of the case, that the nurses were present in court. I've often wondered why they weren't called, and I had the advantage at a conference in Saskatoon a few years ago of meeting counsel who had argued Ayres versus Venner and asked him. And he said, well, it was simply this, that the nurses were very nice people. And I had interviewed them. There were two nurses, elderly nurses, very cooperative, very agreeable. And the other side had interviewed them as well. And we both came away thinking that they're so agreeable, they're going to agree with the last person who talks to them in the witness stand. And so neither of us wanted to call them in chief. And so we wanted to put the notes in that way. But there's an attitude struck by the Supreme Court of Canada, and I suggest that it is an open invitation, which I feel has been sadly neglected by the profession. There are very few cases where Ayres versus Venner has been judicially noticed in any of the reported cases. But it certainly was a welcome sign. Now, some judges have sought to restrict it and say, well, it's only applicable in those cases where the declarants are present in court. Well, if that's all that Mr. Justice Hall was about in Ayres versus Venner, then he didn't have to go through all of that long dissertation about Wigmore and Myers and DPP and so on. And it was clearly an attempt on his part to reform the hearsay law. I bring this to your attention. Of course, at the same time that judicially Justice Hall is reforming the hearsay rule, the profession too is at work. We have the McClure Common Committee here in Ontario that went out to reform the law with regard to medical evidence and gave us our own business records section in the Ontario Evidence Act. So too, at the same time, the Feds amended the Canada Evidence Act to provide business records legislation, at the same time that Hall was doing it. What I find interesting is that the province of Alberta doesn't have any business records legislation. I guess they feel that they don't need it, because the common law will do thank you very much. And indeed, the beauty of the Hall approach, as opposed to the detailed particularity of sections 30 and 36 in the various evidence acts, I think is to be preferred. Ask whether or not there are circumstances guaranteeing trustworthiness. Don't ask if it fits within the pigeonhole of section 30 sub what. The Uniform Evidence Bill, which of course was introduced into the Senate in November of 1982, approaches it in that way. And it does argue for a discretion in the judge to create exceptions not otherwise present. Whether or not the Uniform Evidence Bill will see the light of day, I don't know. We had the advantage of Mr. McGuigan, the Minister of Justice, at our law school late November last year, and in the course of it, someone asked him about the Uniform Evidence Bill, and he sort of said something like it wasn't a great high priority as far as he was concerned, which I think is rather sad. A lot of work has gone into it. Well, I conclude, I have about 2 or 3 minutes left, to simply leave with you 2 cases, to compare 2 approaches to the law of hearsay, and leave it to you to decide which approach you prefer. First case is a case called Dallas County versus Commercial Union. It's an American case, but that's all right. It's an American case. And the issue is this, that the steeple of a city hall in Selma, Alabama has fallen down, and the insurance company is being sued. And the question is, did the steeple fall as the result of lightning striking it, in which event the insurers would be liable, or was it really structural damage within the timbers of the steeple? Which structural damage was left over from a fire that had occurred in the steeple some years before? And the insurance company, of course, argued the latter, in which event they would not be liable. In order to prove its case, it sought to rely on a newspaper clipping, 60 years old, in which the newspaper said there was a fire in the city hall last night and the steeple was badly damaged. And of course you can imagine what the other side said. That's hearsay. You have to call the reporter who was there, who witnessed the fire, to tell us. Okay? And hearsay it is. And this court says, in the Anglo-American adversary system of law, courts usually will not admit evidence unless its accuracy and trustworthiness may be tested by cross-examination. Here, therefore, the plaintiff argues that the newspaper should not be admitted. You can't cross-examine a newspaper, he says. Of course, a newspaper article is hearsay, and in almost all circumstances is inadmissible. However, the law governing hearsay is somewhat less than pellucid. As with most rules, the hearsay rule is not absolute. It's replete with exceptions. Witnesses die, documents are lost, deeds are destroyed, and it goes on this way. And then, I like this thought, he says, there is no procedural canon against the exercise of common sense in deciding the admissibility of hearsay evidence. In 1901, 60 years before, Selma, Alabama was a small town. Taking a common sense view of the case, it's inconceivable to us that a newspaper reporter in a small town would report that there was a fire in the dome of the new courthouse if there had been no fire. He's without motive to falsify. False report would have subjected the newspaper to embarrassment in the community, and he goes through the usual dangers and says, therefore, it ought to be received. That's one approach. This is another approach. This is a case called R versus King. It comes from this jurisdiction. And the question is whether or not, on a speeding charge, the police officer is entitled to testify as to the distance between the two markings on a highway, which markings have been observed, of course, by the spotter plane above. Now, the police officer says, well, I got out and I took my chain and I measured it, and it's 200 yards. And defense counsel, Mr. Carter, says, well, that's hearsay. How do you know that that chain is 200 yards long? And the court says, agreeing with him, as I view the material before us, the police officer, to use a homely analogy, is in the same position as if we were to have used a ball of string, having it on a manufacturer's label stating it to be 200 feet. That's hearsay. The chain, like the string, is not intended as a measuring instrument. To use it for such a purpose, evidence verifying the accuracy of its length is needed. If evidence had been led that the chain had been measured by, say, a tape measure or a yardstick, there then would have been evidence as to the distance between the two markers. Of course, how do we know that the people who put the measuring devices on the yardstick were accurate? Isn't there a certain point where we simply throw up our hands and say, yes, counsel, it is hearsay, but it is trustworthy, and in my discretion, I think we ought to receive it. Thank you very much.
From the time of his graduation in 1970 as a gold medalist from Queen's Law School, Allan Gold has made it very clear that he is destined to be among the leaders of his generation at the criminal bar. A prolific writer, an active and willing teacher, a counsel experienced beyond his years at the bar, Allan is one of those people of whom the rest of us sometimes ask, where does he find the time? It's a mark of the esteem in which he's held by his colleagues that he has since 1979 been a director of the Criminal Lawyers Association. When the planning committee discussed the inevitable charter topic for these special lectures and then focused on the impact of the charter on evidence in criminal cases, the candidate to present the paper was quite obvious. Allan combines an intellectual curiosity with legal skill and tireless energy in a manner that is unique. I look forward to hearing with you his paper. Allan Gold.